more. Now invite questions from the audience. Please. Yes.
Who's raised?
Yes, please. Please mention your name and the question. Yes.
Sir, myself, Shantanu, and I am practicing at the Supreme Court. My question is, since the theme of the session is efficiency in the administration of justice, why the judiciary, by taking into the confidence the government, is not taking any step for initiating the All India Judicial Services for which the amendment is introduced in 1976? What are the impediments into that context? Especially in the wake when so many posts in the high courts are vacant.
It's a good question. This will also help us in determining the All India seniority. But one thing you must appreciate, we have a different set of mindset. The appointment to the judiciary cannot be treated as any All India service appointment, nor at any point of time we can be to the executive. One thing what I say is independence of judiciary. So that being the foremost, even though there is a controversy going on as to whether we must go back to the original system or the present system of collegium or the new system which is likely to be, let us wait and watch. But yes, an All India Judicial Service would definitely go a long way, even though there may be certain demerits to the system, like a person living in North India, if suppose in the lower judiciary, I think you are only referring to the lower judicial All India Judicial Services, if I am not mistaken.
Sir, I mean, a mechanism can be devised by which the lower judicial officers can be incentivized
today,
to be promoted as a high court judges.
I agree. So it will also help in transferring a person from one part to the other and other things. It's a good this thing, maintaining the independence of judiciary. But there are one or two factors, like a judge who is transferred from, say, Delhi to Tamil Nadu. Suppose the proceedings are all in Tamil, he may find it very difficult to adjudicate. So we will have to find out a way how to deal with such a situation. No doubt he can learn the local laws and other things, but language is going to be a big barrier. Suppose an additional district judge, say in Emeritus, is asked to take over as additional district judge in, say, Madurai, then I think the language problem would always be there. I think this will be taken note of, but it's definitely a good suggestion. I think we need to...
Sir, indeed, a mechanism has already been devised with respect to the All India Administrative Services.
That's right.
The same Carter problem operates there also.
It can be.
If I may add one more word, you have in your mind this All India services, administrative, police service, etc. The structure of the service is like this. There is a central segment of the service in All India service. And then in states you got separate cadres. In that center you got separate cadre. People from the states are drawn to the center for certain fixed duration, given postings in the center, and then sent back. But this kind of thing is not, I am told, by the administration once when this topic came up. They don't have a central cadre of judicial officers to rotate. That is one particular difficulty, I believe. Now that you have got enough reply, let us go to the next question. Yes.
I am Gopinath Amin from Ahmedabad. I have 3 bullets to fire. My question is to Mr. P P Rao. So far efficiency is concerned.
Firing at me?
Not firing at you. In a lighter way.
For sharing.
Yes. Government is the biggest litigant. I come across, I am practicing the High Court since 23 years. I have marked one thing, that even one issue is decided, even then, government is again and again making same error and again approaching before the court. I have seen that in second pay commissions, I have filed 70 petitions 7-0. Again and again, they have been deprived. Again, one has to go to the court. Then again, we will have to file another petition. Per person, per employee, we will have to file. Similarly, for length of service, recently I have been working with the retirement employees. There also, once issue is decided, even LP it is decided, again and again same thing is repeated by the government employees. They are fighting the cases. So in that case, as I understand, judgment delivered by the court is binding to everybody. If that is the direction, then they should be taken to the task under the Contempt of Courts Act. That is my suggestion. So that then only that can be curbed and then the areas can be reduced. This is one thing. Secondly, my second point is, so far the government, pleaders have been appointed throughout trial courts. They are appointed by the politicians and they are not meritorious. Many of them you can find totally inefficient. And third question is, so far judiciary is concerned, as is government, periodically there is assessment. If they are found to be inefficient, then the dead woods, they have been removed. But in the judiciary is concerned, there is no periodical check. And that requires to be. These are all three questions that I have posed to Mr. P P Rao.
Well, I would like to share the burden of answering with Mr. Shekhar, who has something to contribute. So for the first question is concerned, you are right. That shows lack of sensitivity on the part of the government and a dogged will to fight and harass the people, even when the issue is closed, covered by the decisions. That's why you find there is a large growing volume of contempt petitions filed in the court, which again consume a lot of time of the court. So therefore, this is a malady. Unless you change the type of governments which are causing this problem will remain. And courts have to also become very strict and stern in dealing with such people. Unfortunately, the thing is, somebody at the top is responsible for this kind of attitude of the government. But the fellow who is alleged to have committed a contempt is the secretary or the director or whoever is the officer concerned. That is another difficulty in the system. Anyway, Mr. Shekhar would like to deal with other aspects. Tell me.
On the first issue, Mr. Amin, I totally agree with you because as a government counsel for the last around 10 years, for most of the department in the Supreme Court, I know in most of the cases, the relief sought by the litigant, private litigant, is already covered by a previous judgment. See, what is the problem here, I must tell you. When something is being deprived to a litigant who feels he is on the right side of law, the first thing he is asked to do is to file a representation, which he does. Unfortunately, his representation does not go to a person who is so legally trained. It goes to a small babu there who simply has to just say, sorry, we don't accept your thing. That man is forced to go to a court to litigate. There also the government pleader who is to vet the counter affidavit, he doesn't discharge his job. For him also, it's an engagement. So this process goes on. As very rightly Mr. Rohatgi said yesterday, the mindset has to change. The government lawyers and the government department must screen and must see that the litigation is reduced wherever the courts have granted relief to a person similarly situated. Straight away, the relief must be granted and the person should not be burdened by going to the court. And if at all, a person responsible for deciding the claim or representation doesn't do, as very rightly Prashant says, that officer must be held individually responsible and a heavy cost must be imposed on such officers. And as far as appointment of government pleader is concerned, well, many of us are victims of that, so I don't wish to, because the matter would be, you may say that I may have a particular opinion, so I don't wish to say anything on that. Yes, you are right. The merits is always, it always takes the back seat, and it is people with a political background and political, this thing only manage to get all these plum postings and plum appointments. So I have no comments to offer.
One thing I would like to add here about this question of political appointments, just to mention to you a practice which is no longer in vogue. Earlier the practice was the government would consult the Chief Justice of the High Court to suggest a panel of names out of whom they could select a suitable person. Invariably, the Chief Justice used to suggest the best he could think of. And out of them, one of them whom they found acceptable, they used to appoint. And those appointments were qualitatively of the highest order. Now, unfortunately, as you said, the trend has become, they said, why should we consult the Chief Justice? Our power. What Chief Justice has got to do with this? They exercise the power, and the range of selection is limited to those who are around them. And then somebody is picked up on those considerations. And in course of time, he becomes eligible for consideration for the bench. That's where the pollution starts. So this is a serious malady it is, but I do not see any hope that in the present state of affairs, anybody would be interested in tackling this problem.
Just to add to that a very short comment. Yesterday, when Attorney General made this announcement that he is chopping off a lot of SLPs at the threshold and not allowing them to be filed, it created a pall of gloom on, to my knowledge, there are around more than 250 advocates to be brought on the new panel, and for them, it is reduction in employment by 1/3.
Yes, I think last question. And
Sir, after you.
So the topic is bringing efficiency in the justice administration. I just wanted to know opinion of this panel. Can video recording of court proceeding be helpful in improving the efficiency of the judicial justice administration?
And it's in all development.
Just I would like you to think of one thing. We have display on TV of the proceedings in Parliament and legislative assemblies. What is your assessment? Has the performance of these houses improved? So therefore, that's a guide. Yes.
See, when we talk about, improving the system, let us not only look at the Supreme Court, High Court. We also have to look at, how the money is to be invested properly. So more than, bringing a kind of technology which is very visible and enticing, we have to first concentrate on introducing utility-based technology. And that is, the first step should be the audio recording. Because, all this system of having to have stenographers, note down orders, judges have to memorize, making short notes, all these things can be done at very less cost in terms of recording the proceedings of the courts in terms of arguments and all. And then, so many in Supreme Court, when you file an appeal even in the High Court and this, they say, oh, you have never argued this point. And the cases are dismissed even on that. And there are so many controversies that, a judge has not very honestly dealt with the submissions. So again, the vested interest comes in. Nobody wants to be under scrutiny. But the right solution right now, given what kind of, resources are invested in judiciary, audio recording is the first step, according to me.
Yes,
Now,
Yeah,
Ms.
my
Rachana
question,
Srivastava, last word to the audience.
Yes, my question is to Mr. Shekhar. Mr. Shekhar, you said that we should not file frivolous petitions and we should give honest opinion to our clients when he comes to us. But you have not defined what is a frivolous petition, because from my experience, not in one case, but in many cases, in 7-8 cases, when I suggested my client that you have totally hopeless case and you need not file this case at all. And the client insisted, and on repeated insistence, I filed that you be ready with the heavy cost that the court may impose upon you.
Can I answer?
Yes, but sir.
The definition of frivolous petition is what the other side files.
Correct. I think she has answered.
Got it?
So my shock, not surprise, but shock, the notice was issued and stay was granted. I could not believe my ears until I saw the certified copy of the order. And ultimately, the appeal was allowed in my favor. So what do you say? What is a frivolous petition? In another case, it was a tenant's petition, and he was already evicted after the High Court's order. Yet he insisted, no, you file this case because my astrologer says if you go to a lady advocate, because it's a Navratra these days, you're bound to get order in your favor. And it really happened. I really wonder what weight with the judges when he is already evicted. It's a tenant's petition. It was, without me uttering a single word, the court said notice to stay. Again, so what is a frivolous petition? If we refuse, then other advocates file and they get the order.
You have made your point. You have made your point. Let me illustrate one small thing by an anecdote. Mr. K. Daftari was defending the Price Competition Regulation Act of Bombay in Supreme Court. Whether it's a gamble or a game of skill, that was the issue involved. And one judge asked Mr. Daftari, can you illustrate what is a gamble? My lord specially puts it in Supreme Court.
Supreme Court. That's right. I think that's also my answer. That was just what I was about to say. But I was similarly situated like this, Rachnaji. When I gave an opinion, I told him. Then he went to the opposite block. He filed. He got an interim stay. That client had the audacity to bring the certified copy and show it to me and throw it on my face. So anyway, that's how it all works. We can't say anything. Maybe.
This is not the first instance. You read P P Justice Bhajankar's biography. Yes. Former Chief Justice Gajanredkar has written an autobiography, to the best of my memory. It's an excellent book. It was posthumously published. In that he mentions an incident when he was a young lawyer. One client came to his house, seeing his board. He studied the paper sincerely. He said, you have no case. Don't file it. I will not file it. He went away, disappointed. 10 years later, a man who could only faintly recollect who was some familiar face, he came to his room again, knocked the door, said, sir, you remember, 10 years back I came to you and I gave my papers. You studied very sincerely and seriously, and they said, I have no case to do it. Please read this decree I have got now. So similar incident which has mentioned. I think now we have had enough of interaction within the limits of time. Now I invite Mr. Roshanlal Jain to propose a vote of thanks.
I thanks all dignitaries on dais, and as well as I thanks to the person in his audience. Thank you very much.